Hello students, I am Gurujit Singh from Guru Gobind Singh University, Delhi. Today our topic of discussion is jurisdiction issue in cyberspace. Now this is very prominent area of discussion in cyberspace because every other day we are using cyberspace as an important mode of communication. Therefore, we need to understand the jurisdiction issue in particular to decide many complicated and technical issues which is arising out of the cyberspace. Now, as per the schedule, the objective of the module is to acquaint students to the importance of concept of jurisdiction, to introduce the innovative methods of jurisdiction developed by USA court in particular, to appreciate the new jurisdiction rules of Indian court relating to cyberspace, to understand the difficulties of jurisdiction in case of international or cross-border issues or crimes, and at the end to make understand the need for uniformity at international level on the issue of jurisdiction in case of cross-border nature of criminal activities. To start with the issue of jurisdiction in cyberspace, first of all I need to understand I need to make you understand the concept of jurisdiction and the concept of cyberspace. The concept of jurisdiction is that this word is coming from or originated from the Latin word juris and dicere. Juris means law and dicere means to speak. So it means the authority granted to a legal body to make pronouncement of a legal matters and in the administration of justice. So it is the jurisdiction of a state or jurisdiction of a court is very important issue. Now there are three important kind of jurisdiction. The first one is prescriptive jurisdiction or legislative jurisdiction. The second one is enforcement jurisdiction, and the third one is adjudicative or judicial jurisdiction. Now these three jurisdiction plays their important role in day-to-day governance of law and order in any other state. Now prescriptive jurisdiction is known as legislative jurisdiction also. It is basically the jurisdiction power of the state to legislate a particular law relating to a issue. Now for the example, if you take the case of India, you will find that center has the legislation power as well as the state has legislation powers. So center legislate within their domain power as well as state also legislate in their domain power, and they try their most not to conflict with each other. So it is the power of the state, and they can make any kind of law relating to any national person or any citizen of this country wherever he resides. It can be within India, it can be outside India also. In fact, Information Technology Act is a very good example of legislative jurisdiction because it governs not only the kind of cases or the offense or contravention happening in India, even if they have started in any part of the country or any part of the world, the Information Technology Act governs the offense and contravention of that under that act. Then the second jurisdiction is enforcement jurisdiction. Enforcement jurisdiction means the power of the state to enforce a particular law. Now laws are enforced by the state agencies, and every agency has its own legislative enforcement jurisdiction. Within that they enforce the laws. Adjudicative or judicial jurisdiction is the jurisdiction of the court to try or adjudicate a matter which is before them. Now there can be different kind of issue which may come before the court, but it is important to see for the court as to whether they can decide the case before them or not, because there might be different kind of parties which may be residing within the jurisdiction of court or not, or the subject matter of the court may not fall under the judicial rule of the court. Therefore, judicial jurisdiction is also important for deciding or resolving a particular case before the court. Now, the important discussion which we are doing here is relating to jurisdiction issues in cyberspace. So, my focus will be the jurisdiction of the courts in cyber case. Now, it is important to understand why we need to talk about this jurisdiction rule in cyberspace. What is so special about it when we have already the jurisdiction rule lying in CPC or Civil Procedure Code and Criminal Procedure Code in India. It is important for us to have this discussion because cyberspace is not a traditional form of space, and the dispute which are created in the cyberspace are therefore are absolutely different from the traditional form of cases. So, what is cyberspace? Cyberspace is nothing but the interconnectivity of different computers and which makes it possible for the user to access the information in this particular platform. Now, the most important unique feature of cyberspace is that it is borderless. So, it does not have any territory. So, any information which is coming from outside can be accessible in India also. It crosses the border like anything, there is no barrier. So, that is the most uniqueness of this cyberspace. Second is that it has unlimited accessibility. You can access the cyberspace at any point of time from anywhere. The most important factor for you to access is that you need to have basic infrastructure with you. If you have the basic infrastructure of computer, internet connectivity, modern, then you can sit at any place and access any kind of information. In fact, you can do any kind of contravention or crime and you can easily do it. Now, that is only possible because it has unlimited accessibility. The next important nature of cyberspace is ubiquitous in nature, that is the cyberspace is everywhere. Now, we have plenty of different kind of technical device such as smartphone and Wi-Fi connectivity, so that we are connected to cyberspace from every other place and we are 24-hour connected to it, and it is everywhere. Therefore, our presence in cyberspace is always, even if we have opened our email account for 24 hours and it is whether we are opening it or not, whether we are accessing the different sort of emails or not, but it is available throughout time. So, it is accessible and it is available all the time. Then the next feature of cyberspace is that dissemination happens spontaneously, and because of this spontaneity it has acquired a large popularity and it is easy to access, as we have already discussed. Then the last one is that duplication or the copy of work happens with very ease. It does not lose any kind of quality when the duplication is happen and the information is intact as if it is the original information. Now, these are some of the important characters of cyberspace. Now, because of this important characters of cyberspace, it has acquired worldwide acceptance. In fact, to the level that now governments around the world are in some way using the cyberspace in their e-governance also, so that they can make the governance more effective, transparent and spontaneity. Now, jurisdiction is important for court for the simple matter because cyberspace is very dynamic, and because it is dynamic, you can access any kind of information or you can do any kind of contravention or crime from any other place, and the ramification or implication of that particular crime will be felt in the physical world. So, it is not that the crime or the contravention is happening only in the cyberspace, but the effect is on the physical world, and because the effect is in the physical world, it is important that somewhere it should be decided, and therefore, the court jurisdiction comes into play a major role. Now, there are different kind of jurisdiction rule which has come up after the invention of cyberspace. Though at the initial time traditional form of jurisdiction rule was very much prevalent, and so the first time any kind of innovative jurisdiction rule was introduced by USA court itself. Now, USA court at this point of time has two important jurisdiction rules. The first one is general jurisdiction and the second one is specific jurisdiction. Now, for the general jurisdiction, the court is relied on very close contact of individual with the state, such as residence and domicile within the state, physical presence in the state at the time of service of process, or some other substantial continuous or systematic contact with the forum state. So, saying thereby, the citizen or the party has to be within the jurisdiction of the court for the application of general jurisdiction by the court. Now, then there is another jurisdiction rule, that is specific jurisdiction rule, under which the defendant having certain minimum contact with the forum state is important for the court to entertain the jurisdiction. Now, different criteria has been developed as to the minimum contact of the defendant with the forum state. So far, there has been two important criteria of this minimum contact. The first one is that the defendant must purposefully avail himself of the privilege of doing business with the forum state. Second, the cause of action arising from the defendant activities in the forum state, and the exercise of jurisdiction would be fair and reasonable. If these three important characteristics of minimum contact fulfills, then the court can have a specific jurisdiction on the issue. Now, court has applied this two jurisdiction rule time to time to find out whether the personal jurisdiction will be applicable or the specific jurisdiction will be applicable. But many of the time it has been seen that due to technical nature of cyberspace, these two tests are not satisfied, and so court has invented a new jurisdiction rule in GPO Manufacture Corporation versus GPO.com Incorporation, which is known as sliding scale test. In this case, the court classified website as passive, interactive and integral to the defendant's business, and held that the place of jurisdiction will be the place of interactive website. So, saying thereby, court for the first time recognized that there are different kind of website which are available. The passive website is only the website which only provides you the information but does not interact with you. It provides some sort of information and it makes it present in the cyberspace, that is it. Now, this kind of passive website does not create any kind of jurisdiction for the court in the other forum. But if it is interactive, then it has been interpreted by court as if the website or the owner of website or the activities of in the website are happening within the forum state itself, and therefore, the court looks for the interactive nature of the website. Integral is those kind of website which can be to some extent passive as well as interactive. Now, whether court can have jurisdiction in integral nature of website or not, that depends on the nature of website. Therefore, it has been seen again and appreciated by court that in many cases it was very difficult for court to understand whether they have jurisdiction or not. Therefore, they invented a new jurisdiction rule in the case of Calder versus Zone, and the test was known as effect test. Now, under this, the court moved from the subjective territoriality test, that is, that a court will regulate an activity only if it is shown having originated in its territory, to objective territoriality or effect test. The plaintiff needs to establish that the website targeted and caused the effect in the forum intentionally or knowingly. So, now this effect test as per the Calder case needs only the effect of the activities in the cyberspace. It can be deliberated or it can't, or it can be innocently also. But if the effect is in the forum state, then the court can have jurisdiction to decide the case which is like before them. Now, apart from these two innovative methods of sliding scale and effect test, The US has a federal long arm statute which takes care of case which doesn't falls in these two important jurisdiction rules, but the plaintiff for that the plaintiff must demonstrate that it has a cause of action arising under federal law. Second, the defendant is not subject to the jurisdiction of the courts of any state, and third, the defendant's contact with the US as a whole is sufficient to satisfy the requirement of due process, that is fair and reasonable. Now coming to India, if we see the jurisdiction rules in India, particularly the civil cases, then we find that the jurisdiction rules are in CPC, that is Code of Civil Procedure 1908, and the rules are defendant centric, saying thereby where the defendant resides or carry on the business, or where the cause of action starts. For this regard, section 19 of CPC is important and section 20 of CPC incorporate the jurisdiction rule. Now section 19 of CPC says, where a suit is for compensation for wrong done to the person or to movable property, if the wrong was done within the local limits of the jurisdiction of one court and the defendant resides or carries on business or personally work for gain within the local limits of the jurisdiction of another court, the suit may be instituted at the option of the plaintiff in either of the said court. Now section 20 is important as it takes care the cross-border nature of cases and the jurisdiction. It says, according to it, there are three important rules of jurisdiction are, the first one, the defendant or each of the defendant where there are more than one at the time of commencement of suit, actually and voluntarily resides or carries on business or personally work for gain, or any of the defendant where there are more than one at the time of commencement of suit, actually and voluntarily resides or carries on business or personally work for gain, provided that in such cases either the leave of the court is given or the defendant who do not resides or carries on business or personally work for gain as aforesaid acquiescence in such institution, or the cause of action wholly or in part arises. Now this is the general jurisdiction rule of CPC. Apart from the defendant centric jurisdiction rule of CPC, Indian legislature has framed a different kind of jurisdiction rule which is also known as specific jurisdiction rule in various acts. Now the two important acts of that nature are the Indian Copyright Act 1957 and Trademark Act. Now the jurisdiction rule in Indian Copyright Act is very much similar to the Trademark Act. Therefore, my discussion only covers the Indian jurisdiction rule in Indian Copyright Act. The jurisdiction is in section 62 and it is plaintiff centric, and it says every suit or other civil suit or the proceeding arising under this chapter in respect of the infringement of copyright in any work or the infringement of copyright in any work or the infringement of any other right conferred by this act shall be instituted in the district court having the jurisdiction. Second, for the purpose of the subsection 1, a district court having jurisdiction shall, notwithstanding anything contained in the civil code procedure or any other law for the time being in force, includes a district court within the local limits of whose jurisdiction at the time of institution of the suit or other proceeding, the person instituting the suit or other proceeding, or where there are more than one such person, any of them actually and voluntarily or carries on business or personally work for gain. Now, the above jurisdiction rule very much highlight that it is the plaintiff place of business is important for the court to decide the jurisdiction whether to decide the case or not. Now there are few cases which has come before the court in which the court has opportunity to decide the jurisdiction in cyberspace. One of the landmark is Banyan Tree case In this case, the court raised three important queries relating to jurisdiction and answered them, and this particular jurisdiction rule in Banyan case highlights that the jurisdiction rule of USA has been incorporated to a great extent in the Indian jurisprudence also. Now, the first question the court raised was whether for the purpose of a passing of action or an infringement action where the plaintiff is not carrying on business within the jurisdiction of a court, in what circumstances can it be said that the hosting of a universally accessible website by the defendant lend jurisdiction to such courts where such suit is filed? The court answered to this query that for the purpose of passing of action or an infringement action where the plaintiff is not carrying on business within the jurisdiction of a court and in the absence of a long arm statute, in order to satisfy the forum court that it has jurisdiction to entertain the suit, the plaintiff would have to show that the defendant purposefully availed itself of the jurisdiction of the forum court. For this, it would have to be the prima facie shown that the nature of activity indulged in by the defendant by the use of website was with an intention to conclude a commercial transactions with the website user, and that specific targeting of the forum state by the defendant resulted in an injury or harm to the plaintiff within the forum state. Court raised the second question that in a passing off or infringement action where the defendant is sought to be sued on the basis that its website is accessible in the forum state, what is the extent of the burden on the plaintiff to prima facie establish that the forum court has jurisdiction to entertain the suit? Court answered this query by saying that for the purpose of section 20C, in order to show that some part of cause of action has arisen in the forum state by the use of internet by the defendant, the plaintiff will have to show prima facie that the said website within, whether euphemistically termed as passive plus or interactive, was specifically targeted at viewers in the forum state for commercial transaction. The plaintiff would have to plead this and produce material to prima facie so that some commercial transaction using the website was entered into by defendant with a user of its website within the forum state, resulting in an injury or harm to the plaintiff within the forum state. So, now you can see in this particular two important questions and answer by the court, you can see that the court has incorporated the effect test as well as sliding scale test of US court judgments, and they have incorporated both of this test in this particular case. So, at the end the judgment says that it can be interactive website for the court to entertain the case. At the same time, if the result of this website is to create some kind of activities in the forum state which is deliberate one, then the court has jurisdiction to decide the case. Now, the other landmark case is Super Cassette Industries Limited versus MySpace Incorporation, and it is a very landmark case decided by Delhi High Court in 2011. In this particular case, MySpace Incorporation had its server somewhere in USA, and Super Cassettes had its office in Delhi as well as in Mumbai. MySpace was providing the facility of subscription of various songs without the permission of Super Cassettes, and therefore violating the copyright of Super Cassette Industries. Super Cassette filed the case for copyright infringement in Delhi High Court, to which MySpace objected that the defendant is a foreign national and is carrying on business outside the jurisdiction of this court, in US. Second, no part of cause of action has occurred within the territorial jurisdiction of this court. Third, the defendant is an amenable personally to jurisdiction of this court and therefore cannot be compelled to be under the jurisdiction of this court. Fourth one, the website of defendant cannot close the jurisdiction of this court as it does not pass the test laid down in the case of banyan tree case. In this case, MySpace was providing the different kind of songs on subscription to various subscribers who were established or who were in different part of the world. Some of the subscribers were Indian also, some of the subscribers were in European countries and USA also, and therefore Super Cassette said before the court that they have economic loss, they are facing economic loss due to this infringement. Now court decided in this case on the basis of section 62 of Indian Copyright Act, the jurisdiction rule. Court held that to sue a foreign defendant, the foreigner must be resident and carry on business within the jurisdiction of forum court. The only exception is if such party submit to the jurisdiction. However, the operation of this rule is not absolute and is subject to the municipal law. If the municipal law provides otherwise or override the private international law principle, the municipal law will prevail. Therefore, in this case, the Code of Civil Procedure are overridden by Copyright Act of 1957 rules on jurisdiction. In this case, since the plaintiff were residing or carrying on business in Delhi, therefore, the court said that the jurisdiction is there with the Delhi High Court. Even if the defendant is residing in USA, but his activities are very much visible and subscribed even in India, in Delhi also. So, it has its effect in Delhi also. On the basis of tort, the court further held that in this case the commission of tort is also important and the jurisdiction can be based on that ground also. The website of defendant is one which is engaged in the online business of providing and exhibiting the songs and cinematograph films worldwide including India. The tort or civil wrong is caused in India as the aspect of downloading to the computer has been occurred in India when the said work is communicated to Indian user without the permission of the plaintiff. In case where the work is uploaded by the user on the foreign server, the initiation of the tort or the part of the same has occurred in India as the infringing work without the authority of plaintiff is communicated to the defendant with the limited license to further modify and communicate further. The said commission of act or a part of the overt act constitute the part of cause of action within the meaning of section 20 of CPC. So, therefore, the court held in the case that the jurisdiction can also be tried in this case on the basis of tort, because the tort has been constituted at the place where the activity has started and it continued till the time it has been downloaded somewhere else. So, the cause of action is continued in the case and the cause of action is also happening in Delhi since the musics are downloaded in Delhi. Now, this is a landmark case and so therefore, with the reading of these two important cases, we can see that though the personal, general and specific jurisdiction of USA court has been incorporated in Banyan case and it has also been reflected by court that it is incorporated in Super Cassette case also. The tort, under tort also the court can have jurisdiction to decide the case because the cause of action is in continuous mode from the place where the things are uploaded and to the place where the things are downloaded. Apart from that, India has a unique jurisdiction rule and that is specific jurisdiction rule under Copyright Act and Trademark Act, which are plaintiff centric. Now, nowhere in any other part of the world the court has plaintiff centric jurisdiction of such nature. Now, this plaintiff centric jurisdiction coupled with effect test is very dynamic, and therefore, taking benefit of these two, the court can always entertain a case even if it has a cross border implications. Now, that was regarding the civil jurisdiction cases. Now, coming to the criminal cases in cyberspace. Now, cyberspace provides ample opportunity for the offender to create any kind of crimes in cyberspace which can have ramification again in cross border. If it is within the nation, then we do not have any kind of ambiguity and we do not have any kind of doubt as to how the court will entertain the jurisdiction, because Criminal Procedure Code of India has the jurisdiction rule, and the jurisdiction rule lying from section 177 to 188 of Criminal Procedure Code amply gives direction to this jurisdiction rule. And the jurisdiction rule is where the offence has happened or where the activity of offence has happened, that is the proper place for the court to apply jurisdiction. This rule is framed for the simple reason that that is the proper place where the evidence can be collected, and so that place should be the proper place of jurisdiction. Now, right from section 177 to 188 section of CRPC define or discuss different variety of jurisdiction cases or nature of jurisdiction cases in different kind of criminal cases. Therefore, we understand that it is the place of crime which is important in criminal case. Now, if the crime is happening within the territory of India, but if it has started somewhere else in some foreign countries, then obviously the important question raised how to whether the court can have jurisdiction of criminal nature or not. Though the things may be happening within the territory of court, the court can even apply its jurisdiction, but without the offender surrendering before the court, how this how the justice can be done in that kind of cases. Therefore, it is important to look for some other kind of concept which facilitate the completion of justice, and that is the concept of extradition with the other countries. Now, if you look into Information Technology Act, which is having in section 75 the legislative jurisdiction, and it says that this act is applied for offence or contravention committed outside India, and it says, subject to provision of subsection 2, the provision of this act shall apply also to any offence or contravention committed outside India by any person irrespective of its nationality. Till that time it is fine, but if the person is not coming to India, then how court can apply the jurisdiction? The second part says, for the purpose of subsection 1, this act shall apply to any an offence or contravention committed outside India by any person if the act or conduct constituting the offence or contravention involves a computer system or computer network located in India. So, it can always happen that a virus can be spread from USA or some other countries, and the ramification of that will be felt in India. But important question is how Indian court can apply the jurisdiction if the defendant is not surrendering to Indian court. Now, in this kind of cases, as I said, the extradition rule is important, because with the extradition only the offender can be brought before the court, and then court can have the jurisdiction and can decide the case. Now, understanding this importance of extradition, we have so far one particular convention on cybercrime, and that is Budapest Convention. and Budapest Convention is basically also known as Convention on Cyberspace. In 2000, it has been created for European countries at that point of time, but realizing the importance of this convention, right now some non-European countries are also member to it, like Australia, Japan and USA. Now this Budapest Convention, because the member countries are party to this convention, so they have a mutual understanding about cooperation and extradition. So even if the offence is happening in one state, but the ramification is in another state, then the court can apply the jurisdiction and ask for the extradition, and person can be brought before the court, and the issue can be discussed and decided by the court. So that is happening. So therefore, at this point of time, understanding the difficulties in criminal jurisdiction case in particular, there is a need for uniformity in criminal jurisdiction, and it is required that India should also be party to this kind of conventions, Budapest kind of conventions, so that we can also take benefit of the cooperation, extradition of criminals in cross-border cybercrime cases, though India is not party to the convention so far. So this is all about the jurisdiction rule in case of civil and criminal cases. So far we discussed in the discussion the jurisdiction rule in case of civil cases and the jurisdiction rule in case of criminal cases. The jurisdiction rule in civil cases, to understand that, we started from USA court, and we found that USA has innovative jurisdiction rule, and then we saw that this to some extent we have incorporated in India the same kind of jurisdiction rule. Then we saw the criminal jurisdiction, and India does not have any kind of convention or does not party to any of the conventions. So therefore, criminal jurisdiction in cyberspace is a problem. With this, I conclude the jurisdiction rule. In fact, I highlighted the important issues of jurisdiction. I hope by following the different concepts of jurisdiction in civil and criminal cases, we can understand the merits and demerits of jurisdiction rules of India. Thank you.